Hi, so today we're going to be talking about the topic contempt of court. Now, when we talk about contempt of court, contempt is any act or omission which is done and it's intended to bring disrepute or disrespect to the court or to interfere with the administration of justice. All right. So if a person or persons do any act or make any omission which is going to be considered to be disrespectful towards the court or to be interfering with the administration of justice, that would be contempt of court. Now, you see that contempt of court are of two types. We have criminal contempt and we have civil contempt. Now, when we talk about criminal contempt, that constitutes an attack on the person of the judge. All right. If you do any act or conduct which would constitute an attack on the person of the judge, on the judge's character, on their integrity, etc., that is criminal contempt. For instance, if a person, let's imagine in court, after the judge gives a judgment, is so displeased and stands up and says, "You're such a corrupt, useless person," that's an attack on the judge's character, on the judge's integrity. And on the other hand, is where there's a willful disobedience of an order of the court. For instance, if the court has issued a summons, all right, commanding a person to appear, and the person willfully disregards it and refuses to appear, now that is civil contempt. So those are the two types of contempt we have. Now, what you should understand is that contempt, whether it's criminal or civil, may be in facie curi or ex facie curi. Now, when we talk about contempt in facie curi, and what that means is that contempt is done in the face of the court, while contempt ex facie curi is contempt that is done outside the court. All right. Now you see that the way contempt is tried depends on whether it was done in facie curi or ex facie curi. So that's in the face of the court or outside the court. Now, if contempt is done in facie curi, so that's in the face of the court, it's dealt with summarily, which means that the judge would simply ask the contemptor, so that's the person in contempt, to enter into the dock and to show cause why they should not be committed to prison. If the person is not able to show good cause why, then the court can go ahead to convict the person and sentence the person. So the person is straight away taken to prison. While for contempt ex facie curi, that's contempt that is outside the face of the court, you would have the allegation reported, the matter will be investigated, and then the contemptor subsequently may be arrested and charged and arraigned before the court. And if the person is found guilty, the person, of course, would be convicted and sentenced by the court. Now, the standard of proof that applies for trials of contempt, both criminal and civil, is the criminal standard of proof beyond reasonable doubt. All right, that's the standard of proof that would apply for the trial of contempt, whether it's criminal contempt, as we've mentioned, or civil contempt. Now, what's the punishment that would apply for contempt? Now, for civil contempt, the maximum punishment is 6 months imprisonment or a fine, while for criminal contempt, the maximum is 3 months imprisonment. And what you should know about the punishment for contempt is that the purpose of the punishment is to basically preserve the honor and dignity of the court. All right, is not exactly intended to exact some hardship or difficulty on the contemptor, which is why if the contemptor, for instance, purges himself, all right, of his contempt, the court would pardon such person. Purging yourself of your contempt means the person maybe is apologetic, has basically realized that they acted, wrongly, in error, and has been very apologetic for what they've done, and the court could pardon such a person. So that's what contempt is about. I hope you've learned something today, and I will see you some other time. Bye bye.